Classic courtroom moment before life-altering decisions get made. The biggest struggle is the microphone. But pay attention, because what starts clumsy is
Oh,
about to turn very serious.
okay. All right. Court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right. And you're Miss Settle? All right. We were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All right. So the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case. And when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And
That's the deal. Drug testing is critical in probation and sentencing. Positive test can mean prison time. But in this case, notice the twist. It's only positive for prescribed medication, not illegal drugs. That detail? It could make or break Elizabeth Settle's future. Page
defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they are able to accept her and can squeeze her in.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see.
This is where the tension spikes. On paper, Elizabeth should be going to prison. But the judge is wrestling with a human question. What happens to her child if she's locked away? Audience, what do you think? Should the law punish strictly, or should redemption weigh more heavily?
The amount of restitution. And state, you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I've known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? Mm-hmm. And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling in programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother.
Notice the defense strategy here. It's all about therapeutic justice. Instead of asking, how long should she serve? The lawyer reframes it as, how do we break the cycle of addiction? That's a huge debate in modern courts. Punishment versus rehabilitation. Which one actually keeps society safer in the long run?
Certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order to enter the drug court program.
All right. Anything you wish to add, State?
Judge, the state stands by its concern about Miss Settle being a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Miss Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean.
9. Judge offering choice. 3 years prison or deferred adjudication with up to 20 years risk if revoked.
Ruka ukazująca do prawa VO5. Cliffhanger plus explanation.
And here's the jaw-drop moment. The judge lays out 2 doors. Door number 1, 3 years in prison, straightforward. Door number 2, probation with deferred adjudication. But if she slips up, it's not 3 years. It's up to 20. This is legal poker at its finest. Low immediate cost, massive long-term risk.
The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand? Sure. And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right. So normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand? All right.
Judge, on the second degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases,